The purpose of this particular lecture is to give you an overview of the Privacy Shield. The EU-US Privacy Shield frameworks were designed by the U.S. Department of Commerce and the European Commission to provide companies on both sides of the Atlantic with a mechanism to comply with data protection requirements when transferring personal data from the European Union to the United States in support of transatlantic commerce. In October 2015, the European Court of Justice declared the previous framework called the International Safe Harbor Privacy Principles, or Safe Harbor for short, invalid. Soon after this decision, the European Commission and the U.S. government started talks about a new framework, and on February 2nd of 2016, they reached a political agreement. On July 8th of 2016, EU member states representatives, called the Article 31 Committee, approved the final version of the EU-US Privacy Shield, paving the way for the adoption of the decision by the Commission, which was adopted in July of 2016. It has already been faced with legal challenges, and its future is uncertain. As in many areas of technology law, stay tuned, there are bound to be changes. The Privacy Shield program as it stands now is administered by the International Trade Administration within the U.S. Department of Commerce, and it enables U.S.-based organizations to join the Privacy Shield frameworks to benefit from the adequacy determinations. To join the Privacy Shield framework, a U.S.-based organization is required to self-certify to the Department of Commerce and publicly commit to comply with the framework's requirements. While joining the Privacy Shield is voluntary, once an eligible organization makes the public commitment to comply with the framework's requirements, the commitment will become enforceable under U.S. law. The Privacy Shield principles comprise a set of 7 commonly recognized privacy principles combined with 16 equally binding supplemental principles, which explain and augment the first 7. Collectively, these 23 Privacy Shield principles lay out a set of requirements governing participating organizations' use and treatment of personal data received from the EU under the framework, as well as the access and recourse mechanisms that participants must provide to individuals in the EU. In order to enter the Privacy Shield, an organization must be subject to the investigatory and enforcement powers of the Federal Trade Commission, the Department of Transportation, or another statutory body that will effectively ensure compliance with the principles. Other U.S. statutory bodies recognized by the EU may be included as an annex in the future. An organization must publicly declare its commitment to comply with the principles, publicly disclose its privacy policies in line with those principles, and fully implement them. An organization's failure to comply is enforceable under Section 5 of the Federal Trade Commission Act, prohibiting unfair and deceptive acts in or affecting, or other laws or regulations prohibiting such acts. Again, the Privacy Shield is made up of 7 main principles. The first one is notice. Notice is the idea that an organization must inform individuals about items relevant to them. It's one of the most extensive requirements that details a variety of different notice requirements, including informing individuals on how to contact the organization with complaints or inquiries, releasing the types of personal data that is collected and how it is used, and the rights of individuals to access that information. The idea behind notice is to inform individuals of their rights in regard to better understanding the standards that an organization must adhere to. The second principle is choice. An organization must provide an opt-out policy for individuals in the event that the information is going to be disclosed to a third party or to be used for a purpose that differs from the original collection. When dealing with sensitive information, an opt-in policy must be provided for individuals prior to the disclosure of information. In the event that sensitive information is transferred, organizations must comply with the notice and choice principles to transfer the information to a third-party organization. In order to transfer the information, organizations must transfer only the relevant data, be certain that the agent is obligated to provide the same protection as is required by the principals, regardless of their own involvement in the Privacy Shield agreement. Take steps to ensure the data is transferred consistently with the principals, remediate and/or stop any unauthorized processing, and provide a summary of its contract with the agent to the department if requested. The next principle is security. Organizations creating, maintaining, using, or disseminating personal information must take steps to ensure its security. In addition, data integrity and purpose limitation is another principle, which basically says information should only be collected if it's relevant to the purpose of processing. Individuals must also be able to access and edit information that an organization has collected about them and delete that information if it's inaccurate. In order to effectively protect information, an organization must have mechanisms to ensure compliance with the principles. For instances of non-compliance, recourse must be made available. Minimum mechanisms include readily available independent recourse mechanisms for complaints and disputes. These are investigated at no cost to the afflicted individual. Follow-up procedures are needed for verifying compliance. You must have the ability to remedy problems to ensure compliance. And organizations and their recourse mechanism must respond promptly to inquiries and requests by the Department for information relating to the Privacy Shield, and organizations must arbitrate claims. A Privacy Shield organization has the responsibility for processing the personal information it receives under the Privacy Shield and the subsequent transfer to a third-party organization. It's important to fully understand the principles and ensure that they are in place prior to self-certification, because organizations can be removed from the Privacy Shield list if they're found to be not in compliance with the principles. The Privacy Shield also creates separate rules for transferring human resources data in order to ensure compliance with labor laws in the member states. Employers generally must comply with the Shield's notice and choice requirements, but they may be exempt from the access requirement in the case of employee security investigations, grievance proceedings, corporate reorganizations, or where it may prejudice sound management. The employer may transfer human resources data only where a U.S. agency has jurisdiction to hear claims against the organization arising out of the processing of employee data. Finally, the employer must provide the Department of Commerce with a copy of its human resources privacy policy. The steps for Privacy Shield certification are, first of all, confirm your eligibility for the Privacy Shield. Conduct a privacy audit. The audit's purpose is to assist in bringing the practices into conformity with the policy and the Privacy Shield principles. Designate a privacy contact person in the company. Draft and post a privacy policy embodying the Privacy Shield principles. And certify online at the U.S. Department of Commerce Privacy Shield website. You will supply information and agree to be bound by the principles and pay a fee. It can range from $250 to $3,250 depending on the company's revenues. Privacy Shield imposes significantly greater obligations upon organizations and their vendors than existed under the previous Safe Harbor framework. In the context of the rights accorded to individuals, these new requirements mirror those set out in the GDPR. Privacy Shield also includes detailed mechanisms for resolving disputes and providing recourse for individuals whose rights have been violated. It will be important to stay up to date on Privacy Shield, as it will likely be modified as areas of concern arise.